Good morning,
Morning.
everyone. Before we get started, Tracy, are you set? Tracy, can you hear me?
Sorry, I thought I unmuted. Yes, I'm ready.
No worries at all. Great, wonderful. All right, everyone, let's go on the record in proceeding number 25F-0178CP, Roman Lysenko versus Rocky Mountain Event Shuttles. I am Kelly Rosenberg, the ALJ assigned to this proceeding. We are here pursuant to decision number R25-0491-I, wherein I set this pre-hearing conference, and in that decision, I did order the parties to be prepared to offer hearing dates that work for them in August and September. Before we proceed, I do want to just make a couple of quick general advisements. First, as a reminder, or if this is new information to you, the commission does record and webcast all legal proceedings, including this one. And we have a court reporter, Tracy, taking down every word. If I mispronounce anyone's name or if I use an incorrect gender pronoun, I mean no disrespect. I welcome your corrections and I'll do my best to get it right from there on out. And finally, because we are virtual, it can sometimes be harder to read body language and it's a little easier to interrupt people. So in an effort to try and avoid that or minimize that, I want to just advise the parties that when I ask a question, unless the question is directed specifically to someone else, I will look to complainant for the first response, and then I will ask for respondent's input. Of course, you will both have a chance to provide your input, but I just want to set that expectation out now to try and minimize some confusion. And at this time, I would like to take appearances, starting with complainant.
My name is Roman Lysenko, and I represent myself.
Thank you. And respondent.
Matt Easter on behalf of respondent.
Great, thank you. So based on the complainant answer, it appears that an evidentiary hearing is necessary for this matter. And just, I don't want details, but I would just like to get your input. Have the parties discussed settlement? Is that likely to occur? Complainant, Mr. Lysenko?
No, I believe it's unlikely.
Okay, great. A respondent?
We have not received any sort of settlement demand, and we're uninclined to make any settlement offer due to the merits of the matter.
Okay. Yeah, I just wanted to clarify that just in case I didn't want to proceed if in fact the parties were pursuing settlement. But it'd be helpful to know that. I imagine this hearing honestly needing about half a day. So with that in mind, I would think we would want to schedule it for one full day, starting from 9 to 5. It will be a virtual hearing, and but I want to get your input in that regard. So, Mr. Lysenko?
Yes, Your Honor, I agree. I believe one full day would be enough. I'm anticipating only having like 2 or 3 witnesses.
Okay, great. And then respondent?
Whatever, we defer to your discretion. Our position is that this is resolved on a pure legal issue. We're not even sure what evidence and facts need to be introduced or what witnesses. As you've read our motion to dismiss, we don't even understand what the injury is and the issue is. We might need discovery to even understand what's going on. Because I'm scratching my head. There's no injury to Roman. There's no grounds for his standing. I'm thoroughly confused, and I'm going to need some assistance understanding how there's a proceeding without any injury.
Okay, well, you're welcome to file a motion or a pleading of some sort if you like.
Maybe a better stated claim, something for more clarification as to the allegations. We're scratching our heads. We have no idea why we're even here.
Okay, understood. And so, but moving on, I understand that, but the purpose of this largely is to set the hearing, but I appreciate
that also really relates to what the timing of the hearing. It's like putting the cart before the horse. If we need to look into things, a hearing date could be premature. But we defer to you. We defer to your discretion.
Have you reached out and tried to obtain discovery?
No, we don't even know why we're here. Mr. Lysenko has not even approached us once. And this is his case.
Your Honor, if I may, can I just speak up? The respondent already had the chance to file motion to dismiss. They already actually provided their concern in the motion to dismiss. Motion to dismiss was denied. I believe that this proceeding should move forward. If the respondent would like to do a discovery, they always can send us a discovery questionnaire. I'll be more than happy to provide that. But I'm not sure, there is no illegal procedure in the CRR 726 is it -1. There is nothing, no motions allowed after that. The motion to dismiss already been denied. So, and I represent general public, and I believe the unauthorized service providers, they are hurting existing service providers by being operating without authorization.
He represents the public.
Okay.
He's the Attorney General. I didn't realize
Everybody,
we were up against the public.
Excuse me.
I thought this was
Excuse
Mr.
me.
Roman.
Excuse me.
Please stop over speaking each other. I will not tolerate that. Do not do that. You will both have the opportunity to speak, but you need to wait your turn. I set that expectation out at the beginning, and I fully expect you to follow that. Mr. Lysenko, go ahead and finish, and then you will have the opportunity to respond.
Thank you, Your Honor. So I represent general public. As a member of general public, I understand how it's important to protect existing authorized service providers. And unauthorized service providers always redirecting traffic from authorized service providers. And I know that it's not in my interest and it's not in the public interest as well. And anybody can file a claim if anybody sees that the company operates as a common carrier without a license, unauthorized, anybody can file a claim pursuant to the Colorado Public Utility rules and regulations.
Okay, thank you for that. Mr. Sedan?
Mr. Sidran, there's an R there. That I had no idea we were up against the general public. I thought this was a claim by a claimant. Again, we don't even know what the injury is. As in all these proceedings, fundamental procedures of due process and notions of fair play and traditional justice are paramount and always apply due to the Constitution of the United States. And if this due process dictates that we need to know what we're being sued for, and if we need to conduct discovery, it sounds like Mr. Lysenko is willing to do that with us informally. If we need to file a motion for discovery, we will. But it sounds like the parties could work this out informally. But the pleading is so vague and conclusory, it would not stand a chance in district court. And we don't know what's going on. So yeah, we're going to have to do this. That could be a wrench in setting a hearing date, but we defer to your discretion in that regard.
All right, well, let's
also,
go.
we also didn't know that there was any sort of QTAM jurisdiction under any of the statute that makes Roman a private attorney general to sue on behalf of the public. That seems like an overreach of the PUC to allow that.
Appreciate that. Okay, thank you. So let's go ahead and look at hearing date options. And it sounds like Mr. Sidran would prefer later, understanding that I understand the issues. I understand your concerns. Let's go ahead and get a hearing date scheduled now. And Mr. Lysenko, let's start with you. I did ask for the parties to be prepared for August and September hearing dates, but let's aim for seeing later in September if that's a possibility, and then we could go from there. Mr. Lysenko, do you have any dates that work for you in September?
Yes, Your Honor. Just one second. And I believe that respondent unnecessarily trying to delay the proceeding, pushing it kind of away from the red drugs season, operation season. So they, I believe for the discovery, they will need only like, a month probably would be more than enough to do the discovery and prepare for the case. So, but I would suggest as early as possible, and definitely pretty much any time in September will work for me. So, except I've got a couple of hearings in September, but I don't think we will be lucky enough to just pretty much the earliest day in September will work for me.
Okay. And just so the parties are aware, we are a little limited in terms of availability. So you, Mr. Lysenko, are pretty open in September. Mr. Sidran, what dates?
I'd just like to address Mr. Lysenko's comments about timing. This is going to be wholly dependent on his forthcomingness and how willing he is to participate. We don't know. And the fact that we have such a conclusory, vague complaint and that he has so many of these proceedings going and they all are conclusory and vague, it all depends on what he's willing to share. And that's going to be the biggest impediment towards getting what we need to be able to defend ourselves as our right to due process entails. As far as dates in September, I am thoroughly booked through mid-2026 with arbitrations and trials. It's like threading a needle in a haystack, trying to find a date. I think it would be best to find a date that's mutually agreeable to the PUC and Mr. Lysenko, and then to run it by me.
Let's see. What about Monday, September 29th, or Tuesday, September 30th?
A 2-week trial in LA. I'm a 2-week trial in LA starting on the 29th.
Okay.
22nd.
Well, I did ask the parties to come prepared to offer dates. So I
got my calendar.
Pardon?
I got my calendar next to me. I'm ready.
What about September 16th?
Works for me.
Mr. Sidran?
I'm looking, I mean, I'd be coming right off a trial in Santa Clara County, going right into an arbitration 2 days later in Southern California. That's really an inconvenient date for me.
Please offer a date that works for you in September.
I'm not prepared to offer any dates. I'm fully booked. I have trials and arbitrations, and these are all prior commitments. If you want to double set me, we can do that, and we could approach it as the hearing comes. But I can't be in 2 places at once, and these are trials to other.
When are you available in August?
Available on the 28th.
August 28th? Mr. Lysenko, are you available August 28th?
Yes, Your Honor, I am.
Okay. At this point, then, let's do that. We'll aim for, I'll set it for August 28th. I do understand the concern about discovery. I have heard Mr. Lysenko today say that he is willing to work with you. So I will ask that you do attempt to resolve any issues you have related to discovery informally. If that isn't working out, by all means, go ahead and let me know, bring me into it. But I will take Mr. Lysenko at his word right now. And so with that in mind, then, so we have a hearing date, and I will set it for 9 to 5 that day. We'll break for lunch, and we could take breaks as needed if the parties need them and the court reporter needs them as well. So next steps are for this is I will take this matter under advisement. I will issue a written decision that will finalize the date of the hearing and its length, and it will include information about exhibits and witnesses and participating in a remote hearing. It's very similar to what we did today. You can expect that in the next couple of weeks. Because of vacation schedules, the decision might be a little bit longer to get out than you may anticipate. So don't be concerned if you haven't gotten the decision in the next couple of days. And are there any other issues for this conference that you have not yet raised? Mr. Lysenko?
Oh, Your Honor.
Mr. Sidran?
Yeah, we got a month now to formally conduct discovery. What we don't want is to be sandbagged at this hearing or be presented with evidence on the 11th hour. That would be fundamentally unfair. So we hope that this could at least be completed in the next week or so. So we'll reach out to Mr. Lysenko and see if he's willing to cooperate.
Great. That sounds very good. Well, thank you everyone for your time. And with that, we'll go off the record and you can expect that decision soon. Thank you, everyone.
Thank you, Your Honor.
Thank you.
Have a good day.
You too.